King on the application of Piffs Elm Limited versus Commission for Maladministration in England.
Yes, Mr. Hunter, Mr. Coppell, we've got quite a lot to get through, but we've done a good deal of reading, so you can really go straight to the points, and we'll slow you up if we feel we want you to go to any of the underlying material with which we're not familiar.
I'm very grateful, my lord. Well, can I just check we are all working from the same documents? We've got a core bundle, a supplementary bundle. You should have 2 replacement skeleton arguments with bundle references inserted, and a copy of Everett in the High Court that my learned friend Mr. Coppell provided. I think that's, as well as a list of issues, I think that is it.
I don't think I've got a copy of Everett in the High Court.
Well, my lord, I think my learned friend has paper copies if that's not made its way to you.
Yes, I sent it by email, but it's probably most convenient, my lord, if it could just go in the same tab as Everett in the Court of Appeal in the authorities bundles. Handout 3,
which is
tab 16 in the authorities bundle.
Thank you. That's volume 2.
Thank you.
My lord, can I take what your lordship has said, that your lordship has been, or that your lordship, my ladyship, has been able to read into the facts of the matter? Because if that's
Yes.
the case, it's probably unnecessary for me to go into those when dealing with the first ground of appeal, which is essentially a question of pure law or a question of functus and the Ombudsman's power or
Yes.
otherwise to revisit their final decisions. So, my lord, if I turn to that straight away, the question is whether the learned judge below was wrong to conclude that it was lawful for the Ombudsman to withdraw the 22nd of August 2019 final report on the basis that the Ombudsman reasonably believed it to be legally flawed. The learned judge did so, derived an implied power by virtue of Section 12 of the 1978 Interpretation Act, and the first and primary submission I make under this ground is that the learned judge, with respect, was wrong to do so. That such a power is not implied, indeed can't be, by virtue of that provision. The second principal submission I make under this ground is that, in the alternative, a contrary intention appears because such an implied power would be inconsistent with the structure, provisions and parliamentary intention underpinning Part 3 of the 1974 Act. The third submission I make is that it would also be inconsistent with established authority, including in particular ex parte Dyer, which until this case was regarded as good law as much for the Ombudsman as the local government Ombudsman as the Parliamentary Commissioner. And my fourth submission is the implication of such power would seriously conflict with the strong and obvious public interest in finality and the related principle that nobody should vex twice in respect to the same matter. The fifth submission I make is that it would conflict with constitutional principle, namely the presumption of regularity, that all official decisions are presumed valid until set aside or otherwise held invalid by a court of competent jurisdiction. The sixth submission I make is that it would circumvent extremely important protections afforded to respondents and interested parties by judicial review procedure and the substantive law of judicial review. And then 2 further points. The 7th point, it would make, or it would give local government ombudsman reports an anomalous status when compared to the reports of other ombudsmen, in particular the Parliamentary Commissioner, but also the Financial Services Ombudsman and the Pensions Ombudsman. And eighth submission, it would lead to the paradoxical situation that the Ombudsman, who is generally not competent to determine legal issues, as the Ombudsman asserts here, can nevertheless determine the legality of his own decisions, subject only to Wednesbury review. Well, if I deal then with the Section 12 of the 1978 Act first. Well, the learned judge addressed this at paragraph 82, page 151 in the core bundle. Well, the court will see there that the conclusion she reached was that the statutory wording, this is the last 5 lines of paragraph 82, rejected the submission I made that it wasn't, Section 12 wasn't capable of being used to apply a power to revoke and retake a decision in the context of the 1974 Act. She rejected that submission and said the statutory wording was wide enough to embrace such situations, and she saw no supporting authority and thought that Johnson was supportive of the position that she took. And therefore, the remainder of the analysis from paragraph 83 onwards was devoted to whether a contrary intention appeared and whether there was any inconsistency with the matters that I've alluded to before. Well, if I can do first with how Section 12 works, because my submission, that's where the judge respectfully went wrong to begin with. In my submission, the purpose of Section 12 is simply to make explicit what is in most cases, not in every case, but will be in most cases, already be obvious. Namely, that a statutory power or duty continues to exist even after it's been exercised or performed, and therefore can be exercised or must be performed whenever the relevant criteria for its performance or exercise are met. And that, in my submission, is the significance of the words from time to time as occasion requires, i.e. as the statute requires or authorises. It is not meant to create a general presumption that statutory duties can be exercised or must be performed, or statutory powers may be exercised on a continuous basis, even within the same case or in relation to the same matter. It may be that some can be, but it will depend on the nature of the duty and its description. And before turning to the power to, or the duty to issue a report and the power to carry out an investigation in the 1974 Act, just to take another example, the court has within the bundle at page 769, tab F, the Town and Country Planning Fees Regulations. And Regulation 3 imposes a duty, or requires, a person who makes an application for planning permission to pay the application fee, unless an exception applies. That self-evidently is a duty only capable of arising upon the making of an application. It's not a duty which Section 7 creates, Section 12 presumes has to be or can be performed continually through the course of the application. The nature and description of the duty tells you it's one that is performed at a particular point in time, repeatedly in the sense every time an application of the requisite nature is made, but not repeatedly in relation to the same application. The same applies to the duty under Regulation 3.5, page 776, the same regulation. A fee provision is the fee paid pursuant to this regulation shall be refunded as the application is rejected as invalid. Self-evidently, again, the effect of Section 12 isn't to presume that a fee has to or can be refunded multiple times. It can only be refunded once by its nature. I'm sorry. The reason for picking out these examples, because they are perhaps more self-evident, is that in my submission the same applies in relation to Section 30. The duty, it is not, first and foremost, it is not a power to issue a report, it is a duty to issue a report, and it's a duty to issue a report upon a certain trigger, namely the completion of an investigation into a matter carried out by the Ombudsman. So the effect of Section 12 is simply to say that is a duty which must be performed on a continuing basis, i.e. whenever the Ombudsman completes an investigation into a matter. It does not imply a duty or power to issue multiple reports in relation to the same investigation after it's completed. And that's why I say Section 12 doesn't have any purchase to begin with. What it certainly can't do, my respectful submission, even if the court rejects that submission, what it can't be relied on to do is to convert a power, so convert a duty or create a power out of a duty. Section 30 is exclusively a duty to issue a report or a statement of reasons at the end of an investigation. It cannot, therefore, by operation of Section 12, be taken to imply a power to issue a report in any circumstances. The most that Section 12 could do, as I say, is imply some form of continuity to the duty. And so it can't be relied on to imply a power either to issue a further report, and certainly not to issue something of a different, certainly not to do something of a different nature, which is to revoke a report with the antithesis of issuing a report. It's revocation. It's simply not apt to derive those implications. Well, could I ask your Lordship at this point, my Ladyship, to take up the authorities and go to the relevant sections of the 74 Act? Because I think, if I could ask you the court to look in particular at section 24 next, which is page 682.
Sorry, where are we going in the authorities bundle?
It's tab A in the statutory materials towards the back of the authorities bundle. So
We've got three bundles. It's helpful if you just tell us which bundle to go through.
It's the third bundle.
Third bundle. Okay. So the second provision that the learned judge relied on was 24A6, which is at page 683 if the court has that. Which the broad power, a broad discretion conferred on the Ombudsman to initiate, continue or discontinue an investigation in accordance with his own discretion. but the concept of discontinuing in my submission, the concept of discontinuing an investigation is clearly that it's distinct from that of completing an investigation. Both result in the investigation being stopped, but in the case of a discontinuance, the investigation is curtailed before it's come to a conclusion. So the natural reading of section 2486 is that the broad powers or discretions conferred on the Ombudsman there all relate to things potentially occurring prior to the completion of an investigation. They are not apt to cover, in particular, the reopening of an investigation after it has been completed. And so, my Lord, I fully accept that, for example, in the case of section 2486, the effect is that the Ombudsman can, on an indefinite number of occasions, decide to stop an investigation and to resume it. We see it happening on the facts of this case, at least in certain respects. Ombudsmen are allowed to change their mind repeatedly during the course of the investigation as to whether it's appropriate to continue all or part of it.
Is there a power, as opposed to a duty, to issue a report prior to completion of the investigation?
Yes, is the answer, I think, to that, because, and that derives from the Ombudsman's general power to regulate his own procedure. So the Ombudsman, the duty is to issue a final report at the conclusion of the investigation under section 30, but prior to that, section 28 Section 28, subsection 2, page 707 in the authorities allows the Ombudsman to adopt such procedure as he considers appropriate in the circumstances of the case. So that allows him to issue draft reports.
So that's where the power for draft reports comes.
In my submit, that is where I would locate it.
And do I understand to be your submission that by describing something as a final report, the Ombudsman is necessarily stating that he has completed his investigations and that it's therefore a section 30 report?
Yes, and I don't understand that to be in dispute. It's the natural meaning. It's how I think it's been understood by everybody, not just in this case, but in others.
Thank you.
And so it's for those reasons, my Lord, that I submit that the judge went wrong at the outset in relying on section 12 to imply the relevant powers. If I'm wrong about that, as I said, my second submission is that a contrary intention is evinced in the statutory provisions. But in order to address that, I'm going to have to take a step back and look at the doctrine of functus officio generally and some of the authorities. If I could start with the definition of functus, again, was the definition adopted by the judge and other judges was that set out in the Demetrio case. That is at tab 27, page 613 of the authorities, which is in the second bundle. Paragraph 42 at the bottom of the page, going over to page 614. The definition is at the top of page 614. A judicial, 4 lines down, the definition is a judicial, ministerial or administrative act that has performed a function in circumstances where there is no power to revoke or modifying it. the next, I think I can leave Demetria for the time being. If I could ask your lordships to take up tab 9, which is the first volume of the authorities sambiting. And within that, page 212, paragraph 3. Paragraph 3, page 212.
Thank you.
Lord Justice Peter Jackson. Once a public authority exercising its statutory power has decided how it's to be exercised, it will lack further authority and be functus officio. Any later attempt to remake the decision will be outside the authority's powers, ultra vires. Aside from these limits on powers, there is a strong and obvious public policy interest in finality which allows individuals to rely on statutory decisions without having to worry that they may later be changed. And then he refers to the 2 acknowledged exceptions in the case of the Housing Act, fraud and fundamental mistake of fact. And also the caveat that a final decision is not to be taken to be made when inquiries are incomplete, citing Crawley. The statement of principle set out there is put in broad terms, and in my submission it is a general rule, but clearly one which is subject to a number of exceptions, not only those that are cited by Lord Justice Jackson there.
Can I just ask at
Yes.
that point where he's talking about fraud, fundamental mistake? I mean, the courts were always said to be functus officio once we'd given a final decision, perhaps refusing permission to appeal. And then we've now discovered that we had the power to reconsider. Would that power apply by way of analogy to the local government ombudsman?
My lord, I was asked the same question in the court below, and
Sorry.
No. If I may give the same, it's the same. I'll give the same answer I gave there. It is no part of my client's submission to deny that is possible. Whether or not it is the case is probably for decision at another time. But my submissions do not preclude that, or shouldn't be taken as precluding that. But for exactly that reason, my lord, it would seem, if I put it provisionally, anomalous if it were not possible for the local government ombudsman to do that when it is possible for the courts to do that.
If an ombudsman were functus, so that any further decision would be ultra vires, what is the juridical basis or source of the power to reopen for fraud or mistake?
As I say, my lord, it wasn't part of my submission to take up a stance on this, but what I haven't done is delve back into the authorities which relate to the court's fraud and the court's power to revisit its decisions. But it's the principle that fraud is something that unravels everything is the one that comes to mind. My lord, if you'd like me to give a better answer to that, would your lordship allow me to think about it over lunch and come back to the
Yes,
court?
because one answer might be it's in section 12. So we may need to look at it.
Well, my lord, that isn't the answer I would give, but yes.
Of course it isn't, but that's why I'm asking you where it is if it isn't in section 12.
But that doesn't put the ombudsman in any different position. From housing authorities, for example, somebody where it's recognised that is an exception. Reasonable belief that the decision is tainted by an error of law isn't a recognised exception, at least in any of the authorities yet. And it's also no different.
Well, there may be 2 separate questions. One is whether there's a power to reconsider at all. You say no. Secondly, if there is, does it go beyond fraud and mistake, and does it extend to what the judge found, I reasonably believe, flawed? But you take your stance on the first point.
Yes. My lord, as I said, the rule is The rule is subject to exceptions. As the judge noted in the court below, paragraph 68, there are competing decisions. In some cases, the courts find the functus doctrine applies. In others, they don't. The judge attempted an analysis to find the factors, the kind of factors which were influential, many of which there is no disagreement about. But my lord, what I would emphasise, when one looks through the authorities, what one sees, that there are, in broad terms, as a judge, are two particular factors that matter: the nature of the decision, and in relation to that, what I would emphasise as being a particularly important factor is the extent to which finality is important, first of all. So one looks at the nature of the decision and how important finality is in that particular context is a critical factor, as is the problems, whether the existence or absence of a power would create significant difficulties. And what I have in mind when saying that, my lord, in Johnson, Mr. Justice Fordham referred to the case of Wilson in the House of Lords, which related to, which was an example of the House of Lords applying Section 12. The question being whether or not the magistrates had power to reconsider the terms of a postponed committal. And both, I appreciate that authority is in front of the court, or it can be obtained if necessary. What was clear in that case was both the wording was apt for Section 12 to have the effect of allowing the court to refix it, but also there was a clear and substantial mischief that would have arisen if that hadn't been the case, namely that when defendants were unable to pay the fine because of changes in circumstances, that have had to be sent to prison, even if the court had entire sympathy with their change of circumstances. So it was extremely compelling for that reason. The second principal factor, which determines the force of the general rule that once a power is exercised, it can't be, or decision made, it can't be retaken again, is obviously the statutory context, the structure, wording, and purpose of the provisions. So the nature of the decision and how it is dealt with in the statute and what can be inferred from how it's dealt with in the statute. In the context of the first, or in relation to the first issue, the nature of decisions, in my submission, what the authorities show is that the presumption that a decision cannot be retaken is particularly strong when the decisions are ones which determine or affect rights and entitlements. And that is the view of Wade and Forsyth, which is reflected at paragraph, or referred to in paragraph 36 in Johnson, page 272. Where the powers have power to decide questions affecting legal rights, the courts are strongly inclined to hold the decision once validly made as an irrevocable legal act and cannot be recalled or revised. The same, and an example of that would be Sambertine itself. Once a person has been determined eligible for assistance under the Housing Act, the Court of Appeal clearly felt that one should lean heavily in favour of a construction which doesn't allow that decision to be revisited. But as well as decisions affecting rights or entitlements, the presumption is also strong in my submission in relation to adjudications. Most clearly in the case of those of a judicial nature, but those also of an administrative nature, and in particular adjudications on complaints of maladministration by statutory ombudsman. And the example, and all the examples where, and the examples of that are primarily Dyer, Parliamentary Ombudsman, functus after he issues a report. Also the Financial Services Ombudsman, re Walker's application, and also the Pensions Ombudsman, Hayward number 2. And the reason why...
Sorry, what was the pensions ombudsman case called?
Hayward number 2, which, my lord, is tab 8, volume 1, page 193. However, can I take your lordship to those authorities first? If we start first with Dyer, please. This is volume 1, still within volume 1 of the authorities.
Divider.
Divider 3.
Thank you.
Begins on page 47. Well, if I could just take some time with this, because I may have to come back to it a number of points. It may be best to pick out the key passages all in one go, and then rather than referring back to it at a later point. Well, if first of all, could your lordships turn to page 49 and letters F to G. We see identified there the complaints that Ms. Dyer raised in relation to the Ombudsman's report that he'd only investigated some of the complaints, committed a number of more important ones. He'd given the department an opportunity to comment on the draft report, but not her. And third complaint that he'd refused to reopen the investigation when she pointed out the other failings, doing the failures considered a number of her complaints. Well, the next passage of relevance is page 53. Letters C to D, where counsel for the Parliamentary Commissioner accepted the similarity between the scheme and language of the 1974 and 1967 Act, as did the court. And then finally, page 55. Firstly, between letters D to E, the assumption by the court and the concession on behalf of the Parliamentary Commissioner that the decision was one, in that case, which would affect the rights of Miss Dyer. I'll come back to the issue of affecting the rights. And then finally, the key part, F to G, Miss Dyer's complaint about the Ombudsman, the Commissioner's refusal to reopen the investigation. It seems to me that the Commissioner is clearly correct in his view that once his report had been sent to Mr. Hattersley in the department, as required by section 10(1) and 2, he was functus officio and unable to reopen the investigation without a further referral under section 5. Section 5.5 confers a wide discretion. Indeed, it does not, however, purport to empower the Commissioner to reopen investigation once his report is submitted. It would seem to me unfair to the Department and outside the scheme of this legislation to suppose the Commissioner could do as Miss Dyer wished.
And what happened to the complaint that it was a bit unfair to give it to one side and not the other?
That was dismissed. My lord, if I can, that is at the end of page 54.
Thank you. It's all parliamentary practice. Yeah.
Yes, my lord. I was going to come back to this, but I might make the point now because one of the reasons given by the judge below for distinguishing or deciding it didn't need to be followed was said that the court then wasn't dealing with an argument that the report had been legally flawed, should be reconsidered because it was legally flawed, but the argument Ms. Dyer was making there, the argument that it was procedurally unfair for her not to have been shown the draft report, looks very much like a complaint that the procedure leading up to the report was legally flawed, at least. And that was how it was dealt with by Lord Justice Simon Brown.
But for the parliamentary aspect of it, might well have succeeded.
Yes, yes, yes. That may be one of the material differences between the local government ombudsman and the parliamentary ombudsman. By contrast with decisions affecting rights and adjudications, including ombudsman adjudication. Oh, sorry, my lord. Sorry, I beg your pardon, my lord. I have omitted. I said I would take your lordship to the court to the other ombudsman's decisions. Rewalker's application. Well, the relevant passage is very brief. They are tab 4, pages 67 and 65. 67, it's highlighted. Clearly, the FSO was functus officio when he made his final decision. If we'd reopened it, it would have been bankrupt when he acted unlawfully. And page 65, paragraph 16. Once the FSO has made his decision on the merits and he's functus officio, no power to change his decision. The only relief available to a disappointed complainant is to apply to the court to quash his decision by way of judicial review. Now, it may be said, and can fairly be said against my reliance on these authorities, that in the case of the FSO and the pensions ombudsman, the statute is explicit. The decisions are final and binding. But that, in my submission, is not a material difference. It was clearly, first of all, it wasn't the case in Dyer. The court reached a conclusion that the parliamentary commissioner was functus officio after the issue of a report, even though the provisions are materially identical to those in the 1974 Act. Nothing expressly saying the parliamentary commissioner's reports are final or binding. But also, my lord, one can see from Eastleigh and Bradley that the courts, not just in ex parte Dyer, but in subsequent cases, have regarded the ombudsman's reports as implicitly final and binding. So if I ask your lordship to take up ex parte Eastleigh, tab 5 in the authorities. Page 67.
Page.
So, my lord, it begins at page 68.
Yeah.
And the relevant passage within it in Lord Donaldson's judgment is at pages 79 and 80. So from letters H to on 79 to C on 80. Two points I would emphasise. Lord Donaldson concludes, based on the provisions of section 34 and subsection 4 and subsection 5 and section 31, 1 and subsections 1 and 2, that the implication of that is that Parliament intended reports to be loyally accepted. The Court of Appeals, we'll see in Bradley, referred to that as them having binding effect. And the second point is the court explicitly considered how a party which was aggrieved by findings in a report could challenge them. Mr. Justice Nolan had concluded that the only remedy was by, as described there, an appeal to media. The Court of Appeal rejected that, or Donaldson rejected that, and said the only way is judicial review. That is letters C to D on page 80. In the absence of successful application of judicial review, the given relief by the court, local authorities shouldn't dispute an ombudsman report and should carry out their statutory duties in relation to it. In Bradley, if I could ask your lordship to turn to the next tab in the bundle. Firstly, if the court could turn to page 104, paragraph 51 in the judgment of Mr. Justice Bean, first instance. Ex parte Eastleigh is therefore an authority for the proposition that in the absence of a successful application for judicial review, the findings of a local government ombudsman are binding on the relevant local authority. And then there was the argument about whether that applied to the Parliamentary Commissioner. Mr. Justice Bean held that it did. The Court of Appeal disagreed. But there was no, they did not doubt that what Mr. Justice Bean had said in relation, as he then was in relation to ex parte Eastleigh, was correct. On the contrary, one can see that Lord Justice Wall explicitly accepted it. So if I ask you, court to turn to page 172. Paragraphs 139 to 140. It follows, so my lord, I'd emphasise the final four lines of 139 and the opening lines of 140. The system, as I understand it, depends on the convention. Local authorities will be bound by the findings of the LGO. It must follow inexorably that if a local authority wishes to avoid findings of maladministration made by an helper, it must apply for judicial review. That was what ex parte Eastleigh was about.
Did Sir John Chadwick agree with what Lord Justice Ward had to say in paragraphs 139 to 140?
No,
Because I picked up that Mr. Justice Blackburn didn't.
yes. Would you bear with me a moment?
I mean, it's quite a long judgment. You don't immediately know the answer to that question.
I will
Yes,
make a
of
note to
course.
come back to it. There's not one I have. What John Chadwick said on the issue was at page 138 through to 141.
Sorry, pages or paragraphs?
Pages 138, paragraph 57 through to 63. I've not been. There is no indication of any dissent from what either Lord Justice Wall said or what Mr. Justice Bean said about ex parte Eastleigh being authority for the proposition that local government ombudsman reports are binding and the only means of challenge is judicial review. There isn't, I have to say on the other hand, I've not been able to detect any positive words of approval or affirmation of that. He simply directs his attention to whether the same principle applies to the parliamentary commissioner.
Right.
Paragraph 128, maybe of assistance. Sir John Chadwick's change.
My understanding of paragraph 128 is simply that Sir John Chadwick simply reiterating that he does not consider that the ex parte Eastleigh is applicable in the case of the parliamentary commissioner. But I will, if I come back to that after I've heard my own friend's submission of it.
But anyway, anything the Court of Appeal said in Bradley about the position of the local government ombudsman would be owed to in any event.
It is, I accept that, albeit my submission consistent with what was said in Eastleigh, and Eastleigh it was part of the decision. Thank you. And in terms of then the academic writings, there is in bundle 3 towards the end short extracts from the local government encyclopedia and the article from Judicial Review, both of which I don't know if the court's had a chance to look at them.
I haven't.
If I could take you the court then to the encyclopedia, for instance, volume 3 of the authorities. Page 903, tab K. Passage, the final paragraph, there's no right to appeal against the report. There's then a summary of Eastleigh, Croydon, and then Belching. And then over the page, the second paragraph at the top of page 904, reference to Dyer, Divisional Court, that once the Parliamentary Commissioner submitted his report, he was functus officio and unable to reopen the investigation without further referral under section 5.1. The same principle presumably applies to the local commissioners, subject to their duty to make a further report under section 31.2a. So assumed in that text, the same rule applied to both Parliamentary Commissioner and Local Government Ombudsman. Similarly, in the article at page tab L, page 907, which looks at functus officio more widely, but specifically addresses Ombudsman and the case of Party Dyer at page 909 to 910. Just ask the court to read paragraphs 14 to 16. You see the author says the Ombudsman is a straightforward case of functus. So again, while it's not binding, there are positive indications in not just Eastleigh, but in Bradley and in the academic writings to support the view that the Ombudsman's decisions have final and binding effect and are suitable for challenge only by way of judicial review.
And what do you say about Balchin then?
Balchin, where the
Which
Well,
is referred to in paragraph 15, which suggested there was power to reconsider.
Well, I think the question was raised by Lord Justice Sedley. I don't think he was even attempting a provisional answer to that. We have Balchin is in the authorities at tab 24, which will be in the second bundle, and it's it appears to be an invitation for submissions on remedy, on relief, after he's given the judgment.
Well, the article's obviously not very impressed by the judgment, but that doesn't mean that it's not right.
No, but
So which page?
it is tab 24. The relevant part of it is page 536, just before the following tab. The second paragraph from the top, I don't consider certiorari is necessary if the Commission will undertake to reconsider his decision. If it is considered his functus officio, it must go. So it seems to have been leaving open the question of what relief was appropriate, rather than deciding.
But you say his preferred view was simply wrong.
Yes, I mean, it wasn't an issue that was addressed in the substance of the judgment, and it appears that he may not have been directed to the authorities before that comment was made.
But so did I haven't read it, Balchin. Did Mr. Justice Sedley decide that the report was unlawful in some way?
Yes, and the relevant passage is just before that, page 535. Second main penultimate paragraph. He found that the Ombudsman had failed to consider a relevant factor of Norfolk's attitude, not with a view to deciding whether it was lawful, you see.
Or to use his own neologism, maladministrative.
Yes. So he did find an error there.
Okay, so what he found was that the Ombudsman had failed to take into account a relevant consideration.
Yes.
So presumably what he was saying in the paragraph, first complete paragraph, which was page 536, was that if the situation is the Commissioner now has a judgment of the High Court saying that the Commissioner has failed to take into account a legally relevant consideration. And what Mr. Justice Sedley appears to be saying is, if the Commissioner will undertake, that means give a formal legally binding promise to reconsider the decision in the light of the judgment, then I don't think certiorari is necessary.
Yes. But he's clearly asking the question, unless somebody thinks that he's functus officio and therefore I will have to make the order.
I mean, the first part of that paragraph assumes that he's not functus, and he does have a part to reconsider.
But he recognises that there might be an argument that he is. Yeah. But he doesn't determine it either way in the report.
Well, he expresses a view in the first paragraph,
yes.
but you say he's wrong about that. It wasn't argued, and he wasn't taken to the authorities.
Yes. And expert party die has, that may be the extent to which it has been doubted, because that that conclusion would be directly contrary to the conclusion in ex parte Dia. As I say, it doesn't appear.
There's another reference in the footnote to Mr. Collins' article to another article. I don't know whether that says something to the contrary, does it? Jones and Grekos, 2001 Judicial Review. The way it's phrased suggests it might go the same way as Belching, but I don't know whether you've looked at that.
I'm afraid I haven't. I can't understand.
Perhaps we could be provided with that.
Yes.
Completeness. Thank you.
But aside from that possible doubting of the position by Lord Justice Sedley in ex parte Belching, the ratio, neither this or any other aspect of the ratio of ex parte Dia has been criticised or doubted in any other case. It is true to say that the authorities which mention it are mostly concerned with general principles about the approach to Ombudsman's decisions rather than the question of functus, but it was cited in Demetrio as an authority in relation to functus, and it wasn't disapproved, it was distinguished by Lord Justice Voss. But not criticised in any way. That is page 614, tab 27, second bundle. The passage, in fact, that the court looked at earlier on. Let us see. No help could be gained from the decision ex parte Dia where the Parliamentary Commission's quite different function had been concluded. And so bring up in terms of the general principles and the authorities, relevant authorities to date, they all pointed towards the conclusion that the local government ombudsman's decisions are final and binding unless challenged by a judicial review, and that the ombudsman is functus once he has issued a report. In my submission, again respectfully, that is correct when one looks at the structure of the Act, the provisions within it, and the parliamentary purpose. And I would draw attention to the following. There is a sharp contrast in Part 3 of the 1974 Act between the broad discretionary powers given to the Ombudsman during the course of his investigation, 24A6 in particular, the broad discretionary power to initiate, continue and discontinue an investigation in accordance with his discretion, the broad discretionary power in Section 8 to be the master of his own procedure. Contrast sharply with the position once the investigation is complete and Section 30 then mandates the Ombudsman to issue a report or a statement of reasons, mandates the relevant authority to advertise the report and make it available to the public for inspection, mandates, Section 31, mandates the authority to consider the Ombudsman's report and provide a response to it, with very limited discretion for those requirements to be varied other than in terms of the time for compliance. There is a sharp contrast between the two stages. pre-completion of the investigation and post-completion. And that sharp contrast is indicative or is, in my submission, inconsistent with the Ombudsman having an implied latitude to reopen the decision after that point, absent a order by a competent court. The second factor I'd highlight is, on another aspect of that, that the Part 3 does clearly give the Ombudsman much scope to change his mind. Again, up to the stage that the report is issued. He can continue, discontinue, he can change his mind about procedure, but once he comes to the end of his investigation, there is no such latitude. He must issue a report, the authority must do what it must do, he must consider what it has done and decide whether it's satisfactory and whether to impose sanctions. It becomes much more prescriptive at that stage. And well, my lady, that's why I prayed in aid. I appreciate the analogy is not exact, but by analogy, what was said in Colonga, where I'm aware 2 members of the court were involved. Paragraph 75, the juxtaposition in closely connected provisions of an express power to change requirements and some provisions. Colonga is tab 17, bundle 2. The paragraph 75 is page 400. My lady, I said, my lady, I said the analogy is not exact, that there is a clear difference between the position in that case where there was express power to extend the period, relevant periods in relation to related types of tenancy, but not flexible tenancies. But the principle, at least broadly speaking, is similar. The Parliament has seen fit to confer considerable discretion on the Ombudsman up to the point he issues his report, including wide powers to change his mind, not thought fit to confer expressly the same latitude after the investigation is complete. And my Lord, if I come to the other considerations, the first, it is unnecessary to imply a power to withdraw and revoke and reissue a report on the basis of perceived legal error, because that is what the courts exist for. Judicial review is a perfectly adequate remedy and the most suitable remedy. Legal disputes, as the Ombudsman says in a different context, should be determined by the court. The legality of the Ombudsman's report should be determined by the court. And it was regarded as a perfectly good and adequate remedy by the Court of Appeal in Eastleigh, Bradley. It is no doubt less convenient for the Ombudsman, but it is more suitable, appropriate and fair judged in the round. in particular from the perspective, so the reason I'll come to so that all parties can enjoy the protections of the judicial review procedure rather than being put at the mercies of the Ombudsman's subjective view as to the legality of his own decisions. The second consideration is finality. A significant problem with the judge's conclusion is that it implies that there is potentially no end to the process. This case provides a stark example of how the investigatory process can be prolonged, taking 3 or more years to come to a resolution, 6 draft decisions in total, 2 final decisions. If it is accepted, as I say, that the Ombudsman has discretion to issue a series of draft decisions, but if the court below is right, the Ombudsman also has power or discretion to repeatedly revoke final decisions if persuaded that there is a legal error. And that's not a fanciful prospect in my submission, because that's what happens at the draft decision stage. The Ombudsman is, and one can have sympathy with the Ombudsman. The Ombudsman is faced with parties, one who says that the latest decision is legally defective for some reason, so he prepares another draft decision, changes his decision, and the positions are reversed. The same could potentially happen after final decisions. Certainly, and in any event, whether or not such a prospect would actually arise, the parties to it would be left in uncertainty as to whether or not that is what might happen. A decision would never truly be final. It would always be open to the Ombudsman to revisit it. It is not like the position, for example, in the parole board cases, such as Dickens and Johnson, where the statute itself or the rules provide for reconsideration on limited grounds. Procedural unfairness and irrationality. And so, and a time-limited period. An implied power would be inherently uncertain, both in terms of how many times it could be exercised and what the time limit for its exercise is. It would conflict with the principle or the presumption of regularity that decisions are proven valid until set aside by court, and it would circumvent the procedural protections and substantive protections of judicial review. In particular, I'm conscious my Lord Justice Popplewell already highlighted that there is a question of what the test would be, but the test, according to the court below, is reasonable belief that the decision is legally flawed. Well, that is a much lower standard, obviously, than the High Court would apply. And it's, in my submission, it certainly cannot be right that if the Ombudsman is given power to, that the Ombudsman has power to err in law about whether his own decision is lawful, so long as it's a reasonable error. But in any event, whatever the test is, the court, the interested parties such as my client would be deprived of the ability to go before an independent and competent body to dispute the Ombudsman's conclusion, and would not have the protections afforded by that in terms of the time limit, in terms of the restrictions on relief, whether it made no difference, and so on. None of those things would come into it if it's primarily for the Ombudsman to decide whether or not to exercise such a power. And as I say, it would lead to the paradox that the Ombudsman, the one legal issue that the Ombudsman can address is the legality of his own decisions, rather than being able to determine law in the context of complaints to him. My Lord, subject to the points on which I've said I will come back to you. That was what I intended to say in relation to ground one and the question of withdrawal and reissuing of a decision. What I propose to deal with next, if I may, is the respondent's cross-appeal in relation to the or the additional grounds on which they wish to rely in relation to the 22nd of August 2019 report. And the first issue, which is identified in the list of issues, number 5, is whether or not the judge below concluded that the August report was unlawful, rather than that the Ombudsman had merely reasonably believed.
Does that issue matter? If the judge was only deciding what the Ombudsman reasonably believed, then it's nevertheless necessary to decide whether depending on the first ground, whether the decision's flawed.
Yes.
If on the other hand she was deciding actually that the report was flawed, then we've got to consider whether she was right or not. So
no, I think
go straight to the substantive question.
Okay, it arose as a procedural issue, I think, because the point was taken that we hadn't directly challenged finding that it was unlawful. We said that it's because she didn't find it was unlawful. But if the court is happy to move to the substantive issue, I'm happy to go straight.
Well, I think the combination of issue 6 and issue 12 makes it look as though it's common ground that whatever view the judge took, there's a question for this court as to whether the report was flawed on public law grounds.
Yes, my lord. There are 3 reasons put forward that were put forward for it in the court below and are put forward again, split across the 2 grounds of the respondent's cross appeal. The first one relates to the question of alternative remedy. And I'll deal if I can deal with that one first. My learned friend submits that the report was flawed because the Ombudsman hadn't applied the statutory bar in section 26(6)(c). And he submits that it was perfectly reasonable to expect the appellant to pursue judicial review, and the report was flawed because it proceeded on the basis that 26(6) wasn't in play and no consideration was given to whether judicial review was a remedy or whether it was reasonable to pursue. A number of points to make in response. The first one is, as the court below held, and as is clear from the case of Croydon, 26, the statutory bar in 26(6) is a threshold bar. It doesn't apply after the investigation has been commenced. And that, we can see that if I could take your lordships firstly to the case of Croydon, page 520 in bundle 2 of the authorities, tab 23. The relevant passage being highlighted.
So sorry, I was just making a note. Could you give me the reference?
Yes, it's tab 23 in volume 2 of the authorities, and it's page 520 within that.
Thank you.
Your Lordship also have the core bundle, tab 9, page 134, paragraphs 19 onwards. The court can see that the judge below, correctly in my respectful submission, concluded on the basis of Croydon that section 26.6 is a threshold requirement that applies when deciding whether to initiate an investigation. It isn't to be it isn't a bar that applies at a later stage. And the implication of that it's paragraphs 19 through to 21, and where the judge expresses explicit agreement with that is paragraph 21, Roman 2 on page 136. Once an investigation has been commenced, 26.6 doesn't itself apply. But if it's apparent the issues under investigation could be resolved in a court of law, the LGO is required to exercise a general discretion to continue or discontinue investigation in a way that reflects the terms and intent of 26.6. My Lord, could I just say in parentheses, all of that in my submission is correct, save for the words is required to exercise in a way that reflects what a Lord Justice Wolfe said in Croydon, was that there had to be regard for those principles, not that one was required to apply the general discretion under 24A6 in the same way as 26.6. But the fact of the matter is, well, the local government ombudsman did in fact apply 26.6. So the criticism that it hadn't been applied in the August report is misplaced. Firstly, because it was too late to take that point, for the Ombudsman to take the point against himself in relation to a report issued years after the investigation had been commenced, or more than a year after the investigation had been commenced. But the Ombudsman had in fact considered the application of section 26.6. The judge noted this at page 140, paragraph 40 in the judgment. You see that the judge there refers to the second draft report issued in May 2018, where he reversed the decision not to investigate the refusal to refund the application fee because it was no longer inextricably linked to the refusal to determine the planning applications. And then 5 lines from the bottom, the Ombudsman said he had determined that it wouldn't be reasonable for Mr. and Mrs. Y to pursue an alternative remedy for this part of the complaint because the failure to return the planning fee was a question of compliance with the planning guidance rather than a strict question of law. That is a reference. Well, it's not necessary to turn up the draft report itself, my Lord, but if I could give you the reference, it's supplementary bundle, page 63. And so one can see the Ombudsman did at that stage consider whether the proviso to section 26.6 should be applied and plainly concluded that it should, that there might have been, whether or not there was a remedy by way of judicial review, it wasn't reasonable to expect the complainants to have resorted to it. And so
was the Ombudsman right to say what he said, as recorded there, that it wasn't a question of law? I think it's said against you that he was wrong about that.
Well, I think my learned friend's attack on it, as I understood it, was directed to the absence of consideration in the August report, not what was said in the 2018 report, my Lord. But no, he wasn't. The answer to the question is no, he wasn't. The request for a refund was put on the basis that the authority had that the planning authority ought to reconsider its position in light of the judgment of His Honour Judge Jarman, which had found apparent bias. It wasn't put on the basis that it was unlawful for them to retain the fee. It was put on the basis that it was what a proper and authority acting reasonably would do.
But by the time of the August report, there was a line before the Ombudsman as to whether there was legal power to refund the fee.
Yes, it had become an issue, yes.
And as I understand the way this point works, the 26.6 point, it is that one of the public law flaws in the August report is that the Ombudsman didn't address his mind to the question as to whether there was an alternative legal remedy. You say, well, there may not be anything in the report that does that, but look at what's said about the second draft report. So he had at an earlier stage done so.
Yes.
But if at an earlier stage he had done so on a flawed basis, I'm not quite sure how that helps you.
Well, the argument that's put in my learned friend's skeleton argument is that he didn't consider 26.6. So the first way it helps is to say that he did.
Yes,
But
the argument
he couldn't consider.
he didn't in reaching his decision in the August report.
No, but he couldn't in the August report for the reasons that I alluded to earlier with Croydon. Section 26.6 is a threshold requirement when an ombudsman decides whether to initiate an investigation. It has no application after he's decided to do that.
No, Croydon says there's a continuing.
There's
a continuing decision to be made as to whether to continue the investigation. That has to take into account, to put it neutrally,
yes,
the same principles. So it would have been open to the Ombudsman. This, as I understand it, is the point that's put against you at the time of making his August report, to consider whether that aspect of the investigation should be continued, and if not, not to continue it. And it's that failure, which I may have misunderstood, but that's what I understand to be the nature of this challenge, this aspect of the challenge to the August report.
Yes, but my learned friend puts the argument in terms of 26.6 rather than 24A6. There is, as Croydon explains, there is the 26.6 is the threshold requirement. 24A6 provides the general discretion, which Lord Justice Wolfe in Croydon says should be exercised with regard to similar considerations. But that's why. They are still a different matter. One is an absolute statutory bar, 26.6. Unless the Ombudsman considers that the proviso should apply, if there is a remedy, it is the complaint is statute barred in effect. The 24A6 is a discretion which should be had with regard to the general policy underlying 26.6, but it is still a discretion. And plainly, other factors must come into play in the exercise of discretion. One may be if you've allowed the history of the complaint. It is not. The Ombudsman can perfectly well conclude that it's not reasonable, even if he thinks that actually, having thought about it again, this is a matter that might be capable of being ventilated in the courts. It's not reasonable for me to go back on that at a stage after In August 2019, there had been 5 draft reports and 1 final report. Any possibility of bringing judicial review at that point must have been remote simply for timing reasons. And so, well, my lord, there would have been, it was, and I'm not, my lord, I'm not sure that it was being put by the local authority that was what the Ombudsman should do at that point. I'm not aware that that was a submission that they were making. This is something that the Ombudsman has said ex post facto should have factored into the decision in August. But my lord, it can't be the case that in every decision the Ombudsman reaches that he has to say, I have considered this factor afresh. I don't think that is how he generally does approach his decisions. So it would be quite onerous if he has to set out in his decision that he has given active thought to the exercise of discretion in accordance with the policy underpinning 26.6. If, my Lord, could I just go to my learned friend Skeleton on, because I'm conscious, I appreciate the point can be put in different ways, but the way it was put in the Skeleton argument at page 10, paragraph 15, is that the August report proceeded on the erroneous basis that the 26.6 principle wasn't in play, wasn't concerned, it didn't wish to confuse complaint about the Section 78 decision. So the council, the investigation was limited to the administrative action of the council in relation to the retention of the third fee. There was no consideration given whether Pell had had a judicial review remedy in relation to the respect of those administrative actions, and if so, whether or not it was reasonable for Pell to have pursued that remedy. But that was precisely what the Ombudsman had already considered in 2018. The complaint had been limited to the refusal to refund. The Ombudsman wasn't invited to, as I understand it, and had no other cause in my submission to revisit the same considerations that he'd had regard to in 2018. And it says at the end of that paragraph, in the absence of any attempt to apply the proviso and any basis for thinking the proviso could be satisfied, there was an important flaw in the report. Well, it didn't have to apply the proviso. The proviso had been applied, and it no longer applied strictly, even if it was the policy underpinning it was a potentially relevant consideration.
Thank you.
And the judge in any event did address this at paragraph 50, page 143 in the judgment.
Yes.
In a 2019 decision, she says the position not as clear as it could have been by the LGO appears to me the LGO's reasoning the scope of this investigation was based on a perceived exercise of its 24A6 discretion rather than 26.6C. She points out that the only iteration that referred to 26.6 was the second draft report. 2019 report referred to the 24A6 powers that were consistent with the decision as to the scope that the document went on to explain. And then page 150, paragraph 75. Under the heading Legal Error in the August 2019 decision. Paragraph 75 records my learned friend's submission that there were threefold errors. Firstly, the 26.6C bar applied entirely or to the entirety of the issues raised by the claimant, so there should not have been an investigation or a decision. Judge rejected that at paragraph 76. My Lord, and I think there's one other point to mention at paragraph 80, over the page 151, the final 3 lines. I don't consider that the LGO believed at the time that he made an error in not applying 26(6)(c, or that he sought to withdraw his earlier decision on that basis. The additional grounds on which the respondent seeks to uphold the judgment below put the matter in 2 ways. First of all, the Ombudsman, the failure to consider or apply 26(6)(c rendered the decision unlawful, but also it's put that it was a sufficient justification if they reasonably believe that it rendered the decision unlawful, that this invoked the implied power.
Yes, the judge here is addressing it in that second context.
Yes, in that second context, and rejecting it on the basis it simply wasn't relied on.
Right, but we have to consider it in the first context.
Yes, both, yes. But well, I think it's put under both, but as I say, yes. That's why I've addressed both. It's both put as a matter of unlawfulness and as a basis for the exercise of the alleged implied power of withdrawal. Well, in relation to the other ground of the cross appeal, which that alleges unlawfulness on other grounds, there are 2 points relied on by the respondent, as there were below. Firstly, that the Ombudsman erred in the August report in having regard to the cases of Harrison and O'Brien as authority for a power to refund, and that the Ombudsman erred in failing to consider whether the council was at fault by taking a wrong view of the law and failing to recognise its discretion. In relation to the first point, in my submission, whilst it is correct that the Ombudsman was wrong to treat them as a demonstration or proof of the existence of a discretion or power, it is an error that makes no difference, because if as a matter of law the Ombudsman was correct that there was a discretion or power, and in the appellant's respectful submission, it is entirely clear that there was such discretion in the form at least of section 92 of the Local Government Act 2000. Well, if I could ask the court to turn that up at tab B in volume 3 of the authorities. The court can see that the power, there is a power or discretion to make payments in case either where the authority accepts that there, or considers that there has been maladministrative action or maladministration, or that there may have been, and that a person has or may have been adversely affected by it.
Did the council ever consider
Yeah, no, the council's response, and the Ombudsman's response to that is to say, well, the council has never accepted that it acted with a maladministration, or that it may have, which is true. But that is because it has never, it did never, at least at the time of the matters complained of, it never addressed the question whether or not what the judge had found demonstrated that it had acted with maladministration. But that can't be an answer to the point, because by way of analogy, for example, a planning enforcement notice can only be issued if a planning authority considers it expedient to do so in relation to a breach of planning control. But if a person were to complain to the Ombudsman that the planning authority had failed to consider taking enforcement action unreasonably and with fault, it would clearly be no defence for the authority to say, well, we have no power to take enforcement action because we haven't yet reached a conclusion that it would be expedient to do so. It's a circular justification. The authority can't say, we had no power to make a payment under Section 92 because we hadn't considered whether we had acted maladministratively or may have acted maladministratively. The power existed, but in a potential form.
Can I just make sure I understand your argument? So your submission is that the council was guilty of maladministration in that it allowed a decision to be taken tainted by apparent bias and therefore had at least a discretion to make a payment?
Yes.
Right.
And that,
I'm sure you put it more elegantly, but
no, I'm afraid I haven't. But I'm sure I haven't. But I will try my best. It is. I mean, the authorities, Bradford, the working definition provided of or referred to of maladministration in Bradford, which is then repeated in Liverpool, Balchin, and Rapp. So it's consistently employed. Gives as I think the first example of maladministration bias. So the locus classicus is Bradford, which is 500, page 500, tab 22 in the authorities. So that would be volume 2.
But my Lord has correctly identified the relevant maladministration you're here relying on, namely that which occurred in relation to the second application.
Yes, so it's
not anything that happened in relation to the third application. Is that right?
Yes, that's correct. Yes, so the argument runs this way, that the judge's finding of apparent bias either entailed guilt, that the authority was guilty of maladministration, or at least that it may have been guilty, at the very least that it may have been guilty of maladministration, and therefore it had power under the Act if it had considered exercising discretion to do it. So there were the first instance of maladministration was the determination of the second planning application tainted by planning, or the appointment of the officer whose involvement tainted the decision with apparent bias. The second maladministration, of which complaint was made to the Ombudsman, was the refusal to consider the authority's position in relation to the fee, having regard to what the judge had found. It refused to take on board the findings and the implications of those findings. That was the complaint. Yes.
So I'm sorry. So your initial answer to me, I think you're now qualifying. It's not the maladministration you're relying on here. Is not only the maladministration by reference to the bias in respect to the second application.
Yes.
It's also, you say, maladministration in relation to the third application.
Yes.
The aspect of it which concerns consideration of refund of the fee?
Yes, not the third application itself, but the authority's refusal to return the fee paid for the third application, even after the judgment which confirmed that the decision, at least one of the decisions on which that refusal was based, or the decision not to determine the third application was premised necessarily on there having been two previous refusals of the same application. The court found one of those decisions was tainted by apparent bias. Necessarily, it follows that the other was as well, because it was the same officer. But formally found that one of them, at least, was tainted by apparent bias. My client said, we understand that previously you have said that you wouldn't return the fee because you were adamant you had not acted improperly by appointing this officer to determine the application. The court has now ruled that you are wrong, that you did act improperly, that there was apparent bias, that it tainted the decision, that it could have resulted in a different outcome. And in these circumstances, reconsider your decision not to refund the fee. The authority said, we see no, and I'll take your lordships to the documents in a moment. The authority says, in essence, there is no justification, we see no justification for this. The judge said what he said, we don't agree with it, and everything we said before still applies. That, in my submission, is more or less the effect of what the council said. And therefore, the operative allegation of maladministration relates to that, the council's response to the request for the refund of the fee. We said, take on board what the judge found and reconsider your decision. They said, we will not reconsider. The justification remains as before. We don't agree with the judge. He said what he said. And I could take you, I think probably is an opportune moment to take your lordships to that.
Sorry to interrupt, and this not on the legal point, but after the judge said what he said, he didn't quash the decision because he said there was a remedy by way of appeal, but there was no appeal.
There was no appeal.
Why was that, or is that completely immaterial?
I think it's immaterial. I also don't have an answer to it. There was a very short period. I think all I could say that there was a short. I can't remember. Referred to 7 or so days. There was a short time frame in which to still file an appeal. The reasons that wasn't done, I think are immaterial. I'm not in a position at the moment anyway to convey them to the court.
Sorry,
but that was the reason that the judge did not grant any formal remedy. Had that not been the case, it may have been different. 17 days, I'm grateful, sorry, not 17. So if the court could take up the supplementary bundle, if we look at the contemporaneous correspondence where the issue was raised. If we start at tab 2, page 5, you will see a letter from my client's solicitors, my instructed solicitors. (14th of November 2016). Referring to the findings of His Honour Judge Jarman, alleging that shows that there were significant failings by the council, and asking it, amongst other things, how it will now exercise its discretion in relation to the return of the application fee for the third application. The response to that from the authority is at tab 3, page 7. The council disagrees with the inferences drawn within that letter, but in the absence of the order and a copy of the transcript, it would be inappropriate to provide a substantive response. So they at least hint at or allude to a likely disagreement with at least the appellant's view of what the judge found. And then over the page onto page 8, tab 4, is the first formal complaint, the stage 1 complaint. The request for the fee is in the first paragraph.
So, sorry, did before the complaint, I'm sorry to interrupt, but before the complaint was made, did the council respond substantively to the request in the letter of 14th of November?
Would you permit my back? Because I believe the answer is no, but I will.
Yes, there's a November. There's a letter shortly thereafter, I think. about a week or two later.
Oh, sorry, I beg your pardon. I thought you meant before. Yeah, I see. Sorry,
Yes, strangely, it's not in the bundles, and in fact, wasn't even in the bundles before the judge. She referred to the response. I think it's the 24th of November.
Right.
I can provide it.
I think that would be helpful because the next letter is the complaint, and then I think there's a response to the complaint. So I find it speaking to myself handy to know what the response was.
again, can I put that on the list of things to obtain and then come back to the court? But the formal complaint was the one at page 8, which was responded to by the council in the document that begins at tab 5, page 18. But one sees that the complaint requested a refund of the fee. It raises the criticisms made, or the adverse finding made by His Honour Judge Jarman. Amongst other matters. And the authority's response at page 18. Page 18.
Is the letter on page 8 a complete letter? There's no
Again, would you?
conclusion. Doesn't end with a sign off.
I'm not. That is the version I see. I appreciate it doesn't have anything at the end that one might expect. Again, if that's something I believe that's the version that's been provided, but I will check whether or not there is a missing part of the letter. The response to it, as I say, page 18, 11th of January. And I think it's important to look at this because the judge interpreted the letter as not placing very much significance on His Honour Judge Jarman's findings, that not forming a significant part of the reasoning. And I think I'd make a number of points in relation to that. The first one is what to make of the letter, and the reasons given in it was a matter for the Ombudsman himself. It wasn't. It was a matter. It was a question of fact for the Ombudsman rather than a question for the court. And the Ombudsman simply didn't address it because the Ombudsman refused to consider the complaint in the context of His Honour Judge Jarman's judgment, which is one of the complaints that is raised on appeal. But if one looks at it, one can see the letter begins by saying the complaint is, paragraph 19, is one of the council not following proper procedure when allocating the application. It refers to the history, the 2 previous refusals. It then refers to the request for a waiver of the fee when the 3rd application was submitted, and the advice that were given, that there would be no waiver, and if the council might refuse to determine the application. So the rest recites the further history, complaining about the delegation to Miss Desmond. And the subsequent court proceedings. And the key part is then on page 20. The complaint refers to the outcome of the judicial review proceedings in respect of the 2nd application, which were opposed by the council as it didn't consider the allocation of the application of Miss Desmond gave rise to any actual or perceived biases. The council's procedures were followed in that it wasn't an application in which it was considered Mr Desmond had any conflict of interest. Judge Jarman considered the decision was tainted by bias. The council does not agree with the judge's analysis of the facts. Nevertheless, he found there being no abuse of power and refused to grant the relief sought, and the judge identified there was an alternative remedy. No planning appeal was submitted. And then the council reiterates in the following paragraph the council did comply with its procedures in that the application was not one in which the case officer was considered to have any conflict of interest. The decision was taken by the planning committee. The procedure followed in the decision of the council, both capable of being challenged within the time limits. The fee was paid and validated. You were advised of the risks and the fee before it was validated, and the conclusion of the position is the fee will not be repaid. So, as I say, in short, the council said the judgment doesn't change anything. We don't accept the conclusions of the judge. We told you before you wouldn't get your fee back, and that remains the position in the judgment. It doesn't alter anything. My client responded to that, page 22. The third paragraph, just over halfway down the page, it's not clear how the council can refute that Judge Jarman concluded that the decisions were tainted by apparent bias. For avoidance of doubt, senior planning officer in the team meeting, Paul Scotland judgment intended to identify the conflict of interest. Then there's a complaint about it being assigned to Mr Skelton. And then finally, I reserve my right to use the response provided to further my complaint if the application fee isn't repaid. The council responds 17th of March, page 27. There is I won't go through it all. There is a recital again of the background to the matter, what the complaint is about, the council not following proper procedures. The letter comes to the findings of His Honour Judge Jarman at page 31. It simply says, the findings of Judge Jarman are a matter of fact, leaving the applicant with the remedy at the time of the High Court decision of appeal. That remedy wasn't taken on either of the two occasions. The almost identical applications for industrial development were refused. And then again, the letter says, similar to the responses to each two complaint, in terms of following normal procedures, no evidence they were processed in a way differently to other applications. At the time they were being processed, the authority didn't consider the planning enforcement to have any conflict of interest. It seems to me as clear to me as it was to the High Court, the appropriate means of testing the soundness and reasonableness of the council's refusal is by way of an appeal. And you could have applied for costs if appropriate at that. There is again reference to His Honour Judge Jarman's decision at page 32. Third line, Judge Jarman made certain findings but confirmed there was no abuse of power and didn't quash the decision. Had he done so, the power couldn't have been exercised, or the discretion couldn't have been exercised because there wouldn't have been two refusals. And they assume on that basis there would have been an entitlement to seek a refund. And then in conclusion, I find no justification to accede to your claim for reimbursement of the fee submitted for the validation of the application. Following this, the appellant complained to the first respondent. The complaint is at pages 34 onwards in tab 8. And if I could just pick out a few key paragraphs of that. Paragraph 1.5 on page 34. The decision of the council to retain the sum 41,244 paid for the application is Wednesbury and reasonable itself, but it's more objectionable by reference to the individual circumstances of the case. Paragraph 1.7 refers to the finding of His Honour Judge Jarman in relation to apparent bias affecting the second application.
Sorry to interrupt.
No.
1.5, does that raise the issue of 26.6 then?
Yes.
Yeah.
And that point has been taken by both respondents that it was identified that it was arguable, that there was an argument at least that the decision was Wednesbury and reasonable, and hence judicial review was a potential remedy. But as I said, the Ombudsman's second decision didn't conclude that there was no alternative remedy. It concluded, or no legal remedy within the courts. It concluded that it was reasonable, not reasonable to expect the appellant to have resorted to it. And that, in my submission, is correct, because it's, as the Court of Appeal said in Liverpool, the growth of the judicial review means that almost any complaint of maladministration could be reformulated as a judicial review claim, but it will not be necessarily reasonable to expect people to pursue all of those as judicial review claims rather than as complaints of maladministration. That was a judgment the Ombudsman reached fairly and reasonably on the facts of this case. Paragraphs 1.9 to 1.13 on page 35. The court will see that the appellant was saying that the court judgment was relevant to the complaint that the authority hadn't returned the fee. Paragraphs 1.9 to 1.11 on page 35. Oh, sorry, 1.13 on 35. And 1.13 alleges that the council had misunderstood and the court judgment. Paragraph 1.15 on page 35 alleges that the council had refused to accept the judge's criticisms, and that was indicative of maladministration. So, in short, the complaint was put on the basis, in relation to the refusal to refund the fee, that one of the critical things that meant that the refusal amounted to maladministration was the manner in which the authority responded to it. Its failure to accept the findings of His Honour Judge Jarman and its misunderstanding of those findings, in particular what he meant by abuse of process. And I highlight that just to say that it was always at the heart of the complaint, both to the council itself and to the Ombudsman.
Because at this stage, there was a challenge not only to the non-return of the fee, but to the Section 70A decision itself.
It was, and that was later abandoned in order to persuade the Ombudsman not to discontinue the investigation altogether. And
maybe said the two go hand in hand. If you're saying you weren't entitled to treat this as a third strike because the second was infected by bias,
well, it was,
and therefore the Section 70A decision is flawed. And what's more, the same reasoning applies to the failure to return the fee, because you're treating this as a third application, whereas it should have been treated as a second application.
Yes, but
that's the approach that's being adopted here. It takes on a slightly different aspect if the first of those is abandoned, doesn't it?
Yes, I mean, the Ombudsman interpreted the complaint as alleging that the decisions were null and void. You see that in the first draft decision, but my instructing solicitors replied saying that wasn't what was being alleged. It wasn't being put quite on that basis. Whether those are, as I said, one can come up with judicial review arguments. Whether or not those arguments were correct or would have succeeded, another matter. But it was But the complaint as formulated to the Ombudsman was a complaint of maladministration. Whether or not it could have also been formulated one way or another as a judicial review claim, it wasn't predicated on His Honour Judge Jarman's judgment having the implication that there were 2 valid refusals. It was accepted that those refusals had to be treated as valid for the purposes of Section 70A. But Section 70A is a discretion, not an obligation. So an authority could always... So it's true to say as well that the authority said, well, it was not a reasonable exercise of discretion. We did say, or the appellant did say, the authority didn't act reasonably when it declined to determine it because it had got itself in this terrible procedural mess with Miss Desmond, and the decisions were tainted by that. But that part of the complaint was abandoned, and all that the Ombudsman was left with by 22nd of August 2019 was a complaint that the council's refusal to refund the fee was, to use the neologism, maladministrative, because it hadn't grappled, in fact, it refused to grapple with the implications of His Honour Judge Jarman's judgment and what they meant about whether it had acted maladministratively previously. That was the essence of the complaint. And, my Lord, we take... that is a diversion, but it will perhaps save a bit of time later on when I come to ground 3. If I go back to the point that it was directed at initially, which is the appellant's cross appeal, and whether or not it matters that the Ombudsman relied on O'Brien and Harrison as evidence of the existence of a power and discretion. As I say, it doesn't matter because it's quite plain that the Council had power under Section 92 because maladministration either had occurred or may have occurred, and that was a basis for them to consider exercising discretion to return the fee. So reliance on O'Brien and Harrison made no difference. The second point, the second criticism made, is that the Ombudsman didn't recognise that maladministration, that a wrong view of the law does not necessarily amount to fault. And to examine that, we have to look at the decision a little bit more closely. So, my lords, my lady, if you could go to the core bundle, tab 19A.
Can I just check one factual thing? We don't have Judge Jarman's judgment, do we?
Oh, yes, we do. In the authorities bundle. Not
it's in the authorities bundle. I mean, not that it matters. Just, thanks.
It is in the authorities bundle, and the relevant parts where he has, where he makes the finding of apparent bias are highlighted. Obviously, there is a lot more background to it, my lord, but unless the court thinks it would assist, I won't take you to that. So in the August 2019 report, tab 19A, page 409, under the heading Conclusions, you'll see paragraph 31, the Ombudsman takes the view that councils have a general discretion to make refunds if it's appropriate to do so. 32 records the council's disagreement, and its reliance on provectus, but says that that isn't determinative. That was a case about whether there's a requirement to refund a fee, not whether there is a discretion. Then the council itself, the council's submission that even if it was wrong, that didn't necessarily amount to fault, is addressed paragraph 33 in the judgment. But the Ombudsman goes on to find, nevertheless, that the council was at fault. And the reason for that, in my submission, one can see in paragraphs 34 to 37, is that the council admitted that it simply hadn't given any thought to the exercise of discretion. So the fault that the Ombudsman found in paragraph 37 isn't getting the law wrong. It's failing to consider its discretion to refund the fee at all. And that finding was made on an entirely sound basis, namely
where do you say we defined the fault in paragraph 37?
Paragraph 37. We therefore find fault with the council for failing to consider its discretion to refund the planning application fee in Mr. and Mrs. Y's case.
And that's the therefore refers back to the reasoning in 34 to 36, does it?
Yes.
Which is,
so
we disagree with the council, they did have a discretion.
No, in my submission it's that the council didn't give thought to the matter.
Where do we get that in 34 to 36?
34. In our view, after considering all relevant information, we find there is a discretion. In response to our draft decision, the council confirmed it didn't give any thought to the exercise of its discretion, because it maintains the only option it had was to apply the statutory fee scale. But the council's position, as I say, was not one. The court has seen in those letters, and it was never said in any of in the letters that were before in response to the stage 1 or the stage 2 complaint. There was no suggestion there. We are not refunding the fee because we have no power to do so. The conclusion of both letters was we see no justification for doing so. So the council's, so my submission, again, whether matters might have been better expressed, but bearing in mind the importance of reading these kind of reports fairly and benevolently, the Ombudsman's central finding that the council was at fault from not having considered exercising discretion was a valid criticism. The second point I'd make in relation to...
I didn't see how that meets the council's point as expressed in paragraph 33.
Well,
if the council's argument was we don't think we have power to do it, then either as what appears next, the Ombudsman says, well, they're simply wrong about that. That's not a complete answer, because if there's room for doubt, that's not to be equated with fault. For the Ombudsman then to say, well, the fault consists in not considering whether they had a discretion, that's rather difficult to square with the submission that they said, we don't think we've got one.
But when my submission, it puts the matter the wrong way around. The complaint was not this. That would all be true if the appellant's complaint had been, the council has refused to refund the application fee because it says it has no power to do so. If the council had said that in 2017 and my client had made a complaint that was maladministration, it would have been perfectly relevant to question whether or not taking a wrong view on that was reasonable or was fault or not. But it didn't. The issue didn't arise like that. My clients, as I say, the council didn't rely on any alleged absence of power until after the complaint was made. And the complaint is necessarily directed at what happened in response to the request for the refund. It's not a moving feast where the complaint shifts to what the council's position has come within the complaints process. For the reasons given by Justice Andrews' issue then was in RAP, that you do not judge whether there has been, the Ombudsman doesn't judge whether there's been fault with the benefit of hindsight. It's based on what's known to the authority at the time. And what the reasons were that the authority relied on at the time. So the authority...
Well, we haven't got that letter at the moment.
I've got it now if you...
I mean, that seems to be fairly fundamental to the point you're making. But that wasn't before the judge below.
Could I check which? Would it? Could I?
Are the parties contend that we should see that? Thank you. It's three that matters.
Three. It's the three that's the key part. So, Lord,
Sorry, do you mind if I just...
Yes, of course, sorry.
Thank you.
So there was no reference there to the absence of a power. Again, what the council relied on was the fact that the appellant had been warned before submitting the application and paying the fee that this might happen. No willingness to consider whether it's appropriate, given what the court found, to return the fee.
The reason given there is not the reason given in paragraph 34 of the determination, is it? In there, the council is saying we can't pay you back because we don't have the power to. Here, they're saying, look, we told you not to make an application. We warned you we weren't going to give you the fee. You made the application, tough. Now, that's an exercise of discretion rather than we have no power. Or reads like that, doesn't it?
Yes, well, yes.
I mean, it may not have been a good reason, but it looks like they've thought they've had a power, decided to take into account that they warned you not to make the application, and you did.
Yes, well, I think that was the way we saw it at that stage. The key point in my submission is that the fact that the no power defence was only raised ex post facto after the matters giving rise to the claim is crucial, because the Ombudsman is considering whether what the council did at the time of its response was maladministration. It therefore has to focus on that, not what the council has subsequently said. The only potential relevance of the council's belated argument that it had no power would be as to injustice, not maladministration. It might have said, well, look, we exercised we thought we had discretion, we exercised it wrongly, or we refused to consider exercising it, but potentially with fault. But it doesn't matter, because the reality of the situation is we didn't have power to refund it anyway. But in that case, the Ombudsman could not have accepted the council's defence without engaging with that issue and reaching a conclusion on it, which they did in the 22nd report, adverse to the council. But it only had, my submission is, the argument that there was no power never had any relevance to whether maladministration had occurred. It only had relevance to whether the injustice had occurred.
I understand that point, but that's not the reasoning that the Ombudsman adopted in paragraph 37, is it?
No. No. But as I say,
the reasoning of the Ombudsman was, you say that you didn't have power, but I disagree with you.
No, but
you did have a discretion to exercise, and therefore you're at fault in failing to exercise it.
Well, failing to consider whether or not to exercise it.
Yes, exactly. So,
but,
yes.
I mean, isn't one way of analysing the letter of the 24th of November to say, never mind what tergiversations the council went into later about whether or not they had a power to make a refund. The premise of this letter is that they have got a power and they're not going to exercise it for the reasons they've given in the letter.
Yes, that is. I mean, that is
your case.
Yes, but one can't fault the Ombudsman for coming to the conclusion that the council had failed to consider exercising discretion, because that's what the council told him, as he records in that part of the decision. The council had admitted that it hadn't considered exercising its discretion, even though I fully accept it looks prima facie like it did. It just reached an adverse conclusion in the contemporaneous material.
We can safely proceed on the basis that the Ombudsman did have the 24th November letter, can we, or not?
Yes. Yes, he was sent it.
Yes.
Attached to the original complaint.
Thank you.
Yes.
Yes, thank you. Well, I understand your submission for my part.
Actually, bear with me in a moment. I'll just see where I'm in my submissions. Yes. So, well, even if, as I say, the failure to consider